Thank you, Mr. Bobbitt.
I have one submission to make today, and that relates to social context and stereotyping. Specifically, the social context of anti-Muslim stereotyping in the post-9/11 world. Context in a case like this is all important, as you've already heard today. And that's because not all unfairness constitutes discrimination. Similarly, not all discrimination is easily distinguishable from unfairness. Looking at the social context allows for a complete assessment of all the relevant factors at play in the decision. Only context in a case like this will reveal the connection that you're looking for between the grounds and the adverse effects. This is the third step of the prima facie case test. And this connection between protected grounds and the negative effects of a decision to exclude is what makes all the difference between unfairness and discrimination. You can't properly answer the question of whether discriminatory factors were in fact at play unless you look at the underlying social conditions in which the impugned decision was made. And that is because discrimination is insidious. This court and other courts have recognized that discrimination operates invisibly, unintentionally, and unconsciously. That is, a person or a decision maker acting in a discriminatory manner can do so without even knowing it, let alone intending it. This court has observed that racism is part of our community's psyche more than 20 years ago, recognizing that a large segment of our community subconsciously operates on the basis of negative racial stereotypes. While discrimination lurks in the shadows and is often not known to the person who is exhibiting the discriminatory behavior, the effects are always experienced and felt. They're real. And this is why anti-discrimination law focuses on effects, not intent, and not good faith, and not good intentions. The effects of discrimination impact the basic dignity of individuals, but they also have corrosive effects on the psyche of a community and on the sense of belonging of minorities. And that's the case for the constituents of my client, the National Council of Canadian Muslims. Since September 11th, 2001, Canadian Muslims have been impacted by the rise in stereotypes that link them to radical ideology and international terrorism. Canadian Muslims live amid conditions of a presumed suspicion that they are potential terrorists or that they sympathize with terrorist ideology or that they cavort with terrorist individuals. As a result, they live in fear of being suspected for their associations, for their activities, for their religious beliefs, for their political expressions, for their hobbies, for their travel patterns, for their shopping, for their jobs. In virtually every aspect of their life, Canadian Muslims face the risk of this heightened suspicion, and that is a risk that other Canadians do not experience. Stereotyping thus creates a chill on constitutionally protected activity. And we have reputable sources that have noted the unequal impact of Canadian security policy on Muslims, from Amnesty International, the Ontario Human Rights Commission, the Bouchard-Taylor Commission in Quebec recognize this. These are cited in my factum. Justice O'Connor in the Arar report noted specifically that Canadian Muslims are more likely to have their human rights violated in the context of national security than other Canadians. Indeed, they carry a higher burden for ensuring national security while they face the exact same risks that any other Canadians face to be victims of national security threats. This is the definition of inequality. And for this reason, it's necessary for this court, and I think it's necessary for the reasoning in a case like this, to recognize that those social conditions, to acknowledge them, as this court has done and many courts have done in the context of anti-black animus in policing. Stereotyping infects decision-making at all levels. And there is no question that in the realm of aviation security and national security more generally, stereotyping links Muslims to higher levels of risk, higher levels of involvement and suspicion of being associated with terrorist activities. And what's the relevance of that context to a case like this? And I don't intend to get into the merits. But in cases like this, where a decision is taken to exclude an individual from the receipt of services, one has to look behind the decision, to look at the way that stereotyping might have clouded the judgment of the decision maker. And here I'm focusing on the decision maker being the respondent, not the American authorities that listed the appellant or the original decision that may lead to an individual being stigmatized or flagged. In Peters, the Ontario Court of Appeal pointed out that when suspicion occurs in the social context of stereotyping, the discrimination inquiry must look behind the stated reasons, because the stated reasons will only give part of the picture. And that is specifically because of the influence of unconscious bias. Decision makers, in particular human rights tribunals, have a mandate to look behind those decisions and to examine the confluence of social factors with the specific facts of a case. And it's worth noting that a service provider is more likely to view information as credible if the information confirms a stereotype. That's a logical conclusion. And on the other hand, a service provider is more likely to accept the possibility of error in information if the information does not align with the stereotype. And if the service provider is not aware of the prevalence of the stereotype or the existence of the stereotype in its own decision-making process, how is the service provider going to make a fair and non-discriminatory decision? And in my submission, when it comes to national security, and in particular aviation security and Canadian Muslims, the mere accusation of being a potential terrorist is essentially a conclusion. And that, again, is something that is not experienced by members of other communities in the context of national security post 9/11, in particular with respect to aviation security. So what can we do about it? What can service providers do about it? Well, the adverse effects of stereotyping can only be mitigated by procedural protections through fair and transparent procedures in order to look behind decisions and to ensure that decisions are reached in an appropriately fair and reasonable way. Where you have a service provider who closes his mind to relevant facts, deliberately chooses to ignore information, and embraces a vague and uncorroborated designation that confirms a prevalent stereotype, and that is plausibly denied by a reasonably credible individual, a reviewing court or tribunal should have no difficulty meeting the relatively low standard required to meet the prima facie case test. This is not a rigorous standard, although the Quebec Court of Appeal, as you've already heard, has raised that standard considerably, and it is cause of concern. Under that standard, it would be nearly impossible for anyone affected by unconscious bias to ever meet the prima facie case. This is a terrifying prospect for members of the community that my client represents. The reasoning of the court would justify virtually any service provider importing virtually any standard and concealing the potential for discriminatory decision-making and shielding their own decision from review. This is a slippery slope. In our submission, the only way to ensure that services are offered in a non-discriminatory manner is to require that the decision to exclude be reasonable, fair, sufficiently tailored to the individual, as accommodation principles require, and based on legitimate and rational objectives that are supported by evidence. And again, without getting into the merits, the tribunal decision addresses all of these aspects, and the tribunal is in the best position to be doing that deep digging into the evidence. A non-discriminatory process would at minimum provide some forum for considering the credibility of the affected individual and to ascertain additional facts. In this case, it appears absolutely none of that was done. I see my time is up. I thank you for your time.